1136, the state of Michigan versus Christopher Moore.
Good morning, Your Honor. Jessica Davidoff for the people, P86743.
Well, Your Honor, Jeffrey Fanta on behalf of Mr. Moore, who is present by Zoom. Judge, this is time and date set by the court for an in-person hearing relative to Mr. Moore for a proposed bond violation. Addressing the in-person issue, Judge, Mr. Moore played me a phone message that came from the court that should have been, I think the court just called the wrong number, and left a message on his number indicating a hearing, but it was directed towards Ms. Butcher. And so he did not have knowledge that he was supposed to be here in person. Number two, I would ask the court, after talking to Mr. Moore, request the court, based upon the landlord-tenant matter that was before the court, I think last week or the week before, would request the court recuse itself and set this matter for hearing before Judge Slavin tomorrow morning. We would be prepared to address the violations at that time. And Mr. Moore will be here in person.
Okay, well, I want to address that. We can set this for the morning. I don't believe that that's grounds for recusal on this case. Mr. Moore was present. There was a landlord-tenant case. His conduct at that landlord-tenant case occurred in my presence in open court on Zoom and on YouTube. And I don't know that anytime someone in a case behaves poorly in a courtroom that I should have to recuse myself. I don't know that that's the appropriate remedy. I certainly believe I can be fair and impartial on this case. I certainly have concerns with the allegations of the bond violations, but at this point, at this point in time, I'm not recusing myself from this case. I don't think it's necessary or appropriate under the judicial canons for me to do so.
Going to be here. Mr. Moore will be here.
Okay. It should be in person.
He will be in person.
Okay. Miss Maudlin, I don't know what our day looks like. What's that?
I have landlord-tenant.
I have landlord-tenant. It ends around 10. My second batch is at 10:30.
I'm here all day, Judge, so whatever.
So Miss Maudlin, maybe we'll just do it around 11:30.
I think there was another case.
All right. Let's just make sure that there's something. I don't know what all we have tomorrow. 11 a.m. tomorrow. Well, Miss Davidova was courteous enough to join us today from the prosecutor's office. This is not her docket. I'm guessing she's got another place to be tomorrow.
I do have court in the morning, Your Honor, tomorrow, but I can make like 11:30 work. I just, circuit court sometimes is backed up.
I get it. Is that okay?
That's fine, Judge.
All right, Miss Davidova, you're free to appear via Zoom. Miss Butcher, you're to appear via Zoom. Mr. Moore, you're to appear in person.
Your Honor, before we go,
Sorry, go ahead.
before we go for the day, can the court inquire where Mr. Moore is presently?
My understanding is Mr. Moore checked in and told one of the clerks that he was out of state right now.
Mr. Moore is not commenting, Judge. He has a right to not say anything.
He's exercising his right to remain silent, Miss Davidova.
All right. Thank you, Your Honor.
And Mr. Moore, just acknowledge that the hearing's at 11:30. I would like you here at 11 so we can talk, okay?
Mr. Moore, you're muted. Okay, I see a thumbs up, so it sounds like he understands.
Yeah, I had asked him to mute himself and not say anything, Judge, so that's a good, perfect response.
Okay, so Mr. Moore, we'll see you in person at the 23rd District Court. Your attorney is requested that you get here a half hour before that hearing at 11 a.m. All right, I'll see everyone tomorrow at 11 a.m. or 11.
Buckle up, guys. Today we're going to dive into a courtroom drama that starts off calm but quickly spirals into chaos. What was supposed to be a straightforward hearing takes unexpected turns, exposing the defendant's questionable actions and setting the stage for a bigger showdown. The judge is composed, the attorneys are ready, but the suspense is already brewing beneath the surface. This is just the beginning of the storm.
Anto, we've got you in here. This is 241136 SM, the people versus Christopher Moore.
Good morning, Your Honor. Jessica Davidoff for the people, P86743.
Morning, Your Honor. Jeffrey Fant on behalf of Mr. Moore. Judge, Mr. Moore has not appeared. I did try to call him. My call went straight to voicemail. I did check with security downstairs. He has not come into the building. To their knowledge, I do not have an explanation for his non-appearance.
All right, and I would just note for the record, Mr. Moore was here yesterday and we set this for today so he could appear in person. He was advised at the time and the date on the record. He indicated he would be present. He's failed to appear. An immediate bench warrant will issue for his arrest. So if he's a flight risk, he certainly at least appears to be, based on the allegations, a danger to Miss Butcher. So he will have an immediate bench warrant for his arrest.
Thank you.
Okay.
Thank you. And Your Honor, for the record, may I note Ms. Butcher is present today on Zoom.
Thank you. I recognize that and I noted it on the file. So, okay, we are all set. And Ms. Butcher, I'm sure that Ms. Davidoff is advised you on what to do in the event there's any contact. And once he is located or picked up or turns himself in, the court will send you notice, okay?
All right, guys. Here the defense tries to push for a recusal, suggesting the judge should step aside because of prior encounters. But the judge stands firm, refusing to back down, and makes it clear that misbehavior won't dictate the course of justice. This is where tension tightens. The defense looks for an opening, but the court won't bend. You can feel the pressure building as the walls start to close in on the defendant.
Your Honor, thank you. Tina Moynihan on behalf of the people, P84-692. Judge, we were in court on Monday. I was there as the prosecutor covering the docket for Ms. Sob and Ms. Davidova. And Mr. Moore was supposed to appear for an arraignment. He did appear by Zoom momentarily and then disappeared. He would not speak with Mr. Gizicki. With my understanding, Mr. Gizicki attempted to have conversations to proceed with the arraignment. And then Mr. Moore decided to log off before the case was ever called. My understanding, he then contacted the courthouse and spoke to a clerk downstairs and made threats to the court that if he came up to the courthouse that something was going to happen to people in the courthouse. And then it was also my understanding of speaking with the complainant who appeared by Zoom that there was an incident in the night prior, which would have been Sunday night. In that incident, Judge, there has been a warrant requested. I am in the process of reviewing that this morning. The allegations there are that the defendant broke into the complainant's home again overnight, forced his way into the home. He then adjusted cameras throughout the home that the complainant had so that he could not be observed. He's seen wearing all black, a hoodie, as well as a mask covering a portion of his face. He then enters the complainant's bedroom. He pulls a gun from his pocket and then shows that to the complainant, claiming that her fingerprints were on that gun and putting her in fear of an altercation ensuing. Further from that, he's then seen leaving the location by the complainant and heading out in an unknown direction. My understanding is that he's been staying across the street at the home across the street from her residence, and I believe that that is also going to be considered a violation of his bond that's been issued, that he's had no contact with the complainant, that he's not returned that residence, and then there's allegations of new criminal activity. In addition, Judge, to his failure to stay in court until the case was called on Monday, I do believe that Mr. Moore is a danger to the complainant as well as to the public as a whole. He shows a wholesome inability to comply with the court's orders. I would be asking for a $250,000 cash surety bond, no 10%, with a GPS tether and house arrest if he were to be released. And I would ask that there be a 2-mile radius from the complainant's residence so that he's not to return to that area.
Now, this is where things heat up. The judge directly confronts the issue of the defendant's location, hinting that he may be out of state, while his lawyer hides behind silence. The moment is sharp. Will the truth come out, or will silence buy him more time? The defendant gives nothing away, but the judge isn't fooled. The suspense grows stronger as the court locks in tomorrow's appearance, sealing the defendant's fate with a warning.
So we probably have to call and get him yet another attorney.
Can you handle the arraignment today?
Yeah, I can I'll do the arraignment, yes.
All right. I mean, he
Yeah.
needs to be arraigned, and so, and then we'll let them know that we need yet another attorney.
Yes. I tried to explain to the client that I would schedule it with him so that we could talk at length, and that really upset him. I did explain that, I needed to go to the courtroom at this point and then speak with him on Zoom at a later date, but he wants another lawyer.
Okay, so let me call these the new one first. This is 241976 People versus Christopher Moore. So Mr. Moore, initially you had an attorney that was appointed through NDS, and they had the attorney they appointed was not I don't want to say qualified, but she didn't meet the standards under the Michigan Indigent Defense Commission's to handle a case of this nature. So she was removed from the case because she can't be on that list. Then Miss Watt was nice enough, kind enough today. She was called to stand in on this or come into the case forthwith so that you could have your court date. So I just want you to know what happened today. So now we have Miss Watt here. It was scheduled at 1:15. All we're handling today is the arraignment. So you're being arraigned on your new case. And I've known Miss Watt for many years. She is a very good defense attorney. And obviously those are decisions you can make, at least for the moment. But I am going to proceed with the arraignment. And then if you want different counsel, Miss Watt, it sounds like there's a breakdown.
Yes.
Okay. So, Mr. Moore, on this case, Ms. Watt, can I get your appearance for purposes of arraignment?
Yes.
If she's going to be...
Cora Watt, appearing on behalf of Christopher Moore, P41508.
Okay. So, Mr. Moore, we can get you a new attorney if you want a new attorney, but I'm arraigning you on these charges.
Your Honor, we stand here to make the formal reading of the warrant on the charges, Your Honor.
Okay. So, Mr. Moore, you have a right to remain silent. Anything you say orally or in writing can and will be used against you in a court of law. You have a right to an attorney, and you have a right to have that attorney present during any future questioning and any future court hearing. If you can't afford an attorney, one will be appointed to represent you, as Ms. Choate was, now Ms. Watt was. And it's my understanding now that, Mr. Moore, you want to fire Ms. Watt?
Correction. I have witnesses in here. She was not listening to what I was finishing trying to say. I had to stop because somebody else, as you can see, there's other court proceedings going on here with several other judges, several other inmates. Got a basketball gym that we're holding court next to. I have cancer. I just had a seizure while I was in custody at Taylor PD when I was picked up. I sat in the hospital for 4 days. I was trying to tell her, she's trying to present an argument, and I'm trying to get her to understand, but then she's saying that she didn't have the discovery package.
Here's the turning point, guys. The defendant doesn't show up. Plain and simple. Despite his clear promise in open court, he skips out, leaving his attorney scrambling with no explanation. The judge wastes no time. An immediate bench warrant is issued. In just minutes, the defendant shifts from fighting bond terms to being a fugitive in the eyes of court. It's the first clear sign that he's losing control of his own case.
Okay, well, Mr. Moore, listen, Miss Watt was appointed to your case 2 or 3 hours ago. So of course she doesn't have discovery. She was just appointed, and that's not her fault at all.
It's clearly not my fault, ma'am. I was asked a question and I was trying to respond.
I'm telling you. All right, Mr. Moore.
All I was simply asking, just let me know when I can speak, please. So we're not.
All right, well, you have 2 dates within the next 21 days. The first is your probable cause conference, which is set for September 4th of 2024. Following that, you will have a preliminary exam. You are to appear in person at that hearing, and that is September 9th of 2024. And we will get this back down and have another attorney appointed to represent you. Mr. Moore, are you telling me that there's been a breakdown between you and Ms. Watt that you believe affects her ability to represent you?
I didn't
Yes
say
or no?
anything. She said that she was going to go back into the courtroom. This is what she said. I didn't even say anything. She said she's going back in the courtroom. Oh, this ain't going to work. I was like, what's not going to work?
I don't speak like that, first of all, Your Honor.
All right. Well, let me ask you, Ms. Watt, instead of Mr. Moore, Ms. Watt, has there been a material breakdown where you can't represent him?
Yes, Your Honor.
All right. So you're being removed from the case.
Thank you, Your Honor.
But I'm setting bond on this case. Now, he currently has a $250,000 cash surety bond on his other home invasion case. This one is certainly even more concerning. So, because now he's gone to home invasion first.
Home invasion, what are you talking about? When did this happen, ma'am? Your Honor?
This part is chilling. The prosecutor lays out shocking new allegations. The defendant is accused of breaking into complainant's home, tampering with cameras, and brandishing a gun. The accusations paint a terrifying picture of escalating violence, leaving no doubt that the case is spiraling. What started as bond concerns now looks like a full-blown threat to public safety, and the stakes rise to dangerous new heights in this jaw-dropping reveal.
You know what, Ms. Watt? I don't want there to be any confusion or anyone to say nobody did their job. So here we go. The allegations are that the date of occurrence is August 12, 2024, and the witnesses state that on the date at that location, the defendant, contrary to law, committed count 1, home invasion, did break and enter or did enter without permission a dwelling with the intent to commit an assault therein, and while entering, present in, or exiting the dwelling, Shamani Butcher was lawfully present therein and or was armed with a gun, a dangerous weapon, contrary to MCL 750-110A, parent 2. That is a felony punishable by up to 20 years in prison and a fine and or $5,000 fine. A consecutive sentence may be imposed for any other conviction arising out of the same transaction. Count 2 is weapons, felony, firearm. The allegation is that you did carry or have in your possession a firearm, to wit, a handgun, at the time you committed or attempted to commit a felony, home invasion first degree, contrary to 750-227B. That is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. Mandatory forfeiture of the weapon or device. Count 3 is weapons, firearms, possession by prohibited person. The allegation is you did possess and or use a firearm when ineligible to do so because he or she had been convicted of assault with intent to do great bodily harm, less than murder, and or uttering and publishing an offense punishable by imprisonment for more than 1 year, and the requirements for regaining eligibility had not been met, contrary to MCL 750-224F, parent 6. That's a felony punishable by up to 6 years and or $5,000. Count 5 is assault with a dangerous weapon, felonious assault. And it alleges that you did make an assault upon Shamani Butcher with a dangerous weapon, to wit, a handgun, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. That is a felony punishable by 4 years and or $2,000, DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750-506A if the assault was committed in a place of confinement. Count 8 is weapons, felony, firearm.
There's no charges on this, ma'am?
I'm still reading your charges. We're on number 6.
I'm sorry. I didn't mean to interrupt you, ma'am.
All right, well, listen.
Okay.
You want to know, I'm telling you.
Yes, I wanted to know.
Did carry or have in his possession a firearm, to wit, a handgun, at the time he committed committed or attempted to commit a felony, to wit, assault with a dangerous weapon, contrary to MCL 750-227B. This is a felony punishable by 2 years consecutively with and preceding any term of imprisonment imposed for a felony or attempted felony conviction, mandatory forfeiture of the weapon or device. Count 7 is domestic violence, and the allegation is you did make an assault or an assault and battery upon Shamani Butcher, an individual with whom you have a child in common, contrary to 750-81, parent 2. This is a misdemeanor punishable by up to 93 days and or $500. A consecutive sentence may be imposed under MCL 750-506A if the assault was committed in a place of confinement. You are charged as a habitual offender, and there is a fourth offense notice on your information or complaint.
This was all on August 12th at what time, ma'am?
There's not a time on here. It said it's at August 12th at this
Okay, so-
location. No, I'm still reading, Mr.
Oh, okay.
Moore.